Good morning. Am I audible? Good morning. Good morning. If I'm audible, please just let me know. Drop in a message, please, in the chat. I don't know why I'm not able to see live chat. Just give me a minute. I'll just be back. I'm here only. I'll just check out why my live chat is not working. Okay, good morning. Now I can see, and I'm so sorry you had to wait for 5-10 minutes because I just couldn't see. Are you able to hear me now? Are you able to hear me now? Am I audible? Okay. So, how is your studies going on? I hope you all are studying, like really studying. And also, is the Indian Contract Act summary notes visible? Okay. So we are going to start with the Indian Contract Act. We have already done the revision of Sale of Goods Act, Contract Companies Act, and Partnership Act. Companies Act, in fact, we had done it in the morning only. Okay, then it's fine. Zabardast, then it should be Zabardast only. Your padhai should also be Zabardast. Your exam should also be Zabardast tomorrow. So Indian Contract Act 1872, it came into force on the 1st of September 1872, applies to the whole of India. So what's a contract? A contract is an agreement which is enforceable by law. When we say agreement, agreement is every promise and every set of promises which form consideration for each other. What is enforceable by law? What is enforceable by law? Enforceable by law means the party has a right to go to the court. What is a promise? A proposal, when accepted, becomes a promise. So, what is a proposal? A proposal is willingness to do or not to do something with a view of obtaining the other person's consent to such acts or abstinence. And what is acceptance? When the person to whom the offer is made signifies his consent thereto. Is there an issue with the voice? Is there an issue with the voice? Just a second. Now see, is it fine? Now is it fine? Now is it fine? Now it should be fine, I guess. Okay, one now is it okay? Now is it okay? Okay. So moving on to the next one. So on this basis, we can conclude that agreement is offer plus acceptance, and offer plus acceptance plus enforceable by law is a contract, or agreement plus enforceable by law is a contract. Now, what are the essentials of a valid contract? The essentials of a valid contract are given both under the Act, as well as there are certain other essentials which are not given under the Act but are equally important to make a contract valid. Over the years, we have found that these are equally important, though not given in the Act. First, let's talk about what are the essentials as given under the Act. Section 10 gives us the essentials of a valid contract, which is offer plus acceptance, then consideration, capacity to contract, free consent, lawful object, and agreement not expressly declared void. Apart from this, over the years, we have realized that these are the other essentials which should be present to make the contract valid. They are two parties. Please keep recalling with me, keep telling with me, keep, wherever you're sitting, keep recalling, speak out loud, not just listen, okay? Speak out loud. So, two parties intention to create a legal relationship, certainty and possibility of performance and legal formalities. And when all these 10 essentials are present, we can say the contracts are valid. Now, on the different types of contracts, we can classify the contracts on different bases. On the basis of validity, on the basis of formation, and on the basis of performance. On the basis of validity, we have void, voidable, valid, illegal, unenforceable. On the basis of formation, we have express, implied, and e-contracts. And on the basis of performance, we have unilateral, bilateral, and executed, executory, and partly executed, partly executory. What is valid, which is enforceable by law at the option of both the parties? What is void, which is not enforceable by law? What is voidable, which is enforceable at the option of one of the parties? What is illegal? It is void as well as punishable by law. What is unenforceable? Substance is good, but there are technical defects. Then, on the basis of formation, we have express, implied, and e-contracts. Express is by words, oral or written. Implied is by either by actions or by law. When it is by actions, it's tacit. When it is by law, it's quasi. So what is by law? Contract is created by the imposition of law. What is tacit? When the contract is inferred by the acts of the parties. Then again, on the basis of formation, one last e-contract which is formed over the internet. Then on the basis of performance, we have unilateral, bilateral, executed, and executory. Unilateral, one party performs before or at the time of contract, the other will perform after the contract is made. Bilateral, both are yet to perform. Executed, both have performed. Executory, reciprocal promises which have to be performed. Now, on the base, after the unit, first unit is over, we are going to start with all the essentials of a valid contract in detail. Before I go to the next one, if you have any doubts in any of it, ask me first and then we move to the next one. Chinu, you had asked me what is quasi contract. So basically, these contracts are not made by the parties, but they are created by law. There is actually no contract between the parties, but by law. No, there is no amendment, Jayashree. But by law, the contract is created. Okay. But by law, the contract is created. Apart from this, right now, I will not tell you anything. The reason being that once we go to the last unit, we will do this in details. Okay. Now, what is offer? Moving on to the next essential, what is offer? Willingness. Offer is willingness to do or not to do something with a view of obtaining the other person's consent to such acts or abstinence. So basically, I want you to do something or I don't want you to do something, and for that I make an offer so that you will accept it. So when this is present, we can say it's a valid offer, right? When all this is present, we can say it's a valid offer. Now, what are the different types of offer that we have? Offer may be general, special, cross, counter, or standing offer. General offer is it is made to the world at large, that is to the public. Anyone from the public can accept it. may move forward, come forward, act accordingly and accept it. What is special? It is made to a definite group of person or per person. When I said a special offer, it can only be accepted by the person or group to whom it is made. Cross offer is we both make identical offers to each other, but we both are not aware of the other's offer. The result of cross offer is both the offers will lapse. Counter offer is a modification of the original offer. When I make an offer to you and you accept it with modifications, you have made a counter offer. Counter offer results in the lapse of the original offer. Standing or open offer, which is open for acceptance over a period of time. That is, I give the offer to you and I say that within this period of time you should accept my offer. This is a standing or open offer. Now, there are certain rules of an offer, and only when these rules are present, the offer is valid. Offer must be definite, clear, and not vague. It should be, the terms of the offer should be such that it could be understood by the other person. It may be express or implied. Express is by words, implied is by law, by action. Sorry, there is nothing like implied by law here. Types in rules of offer. Offer can be either by words or by actions. Offer must be communicated to the person whom it is made. So when the offer is made to the offerer, it has to be communicated to the offerer, only then it is a valid offer. Can I accept an offer without even knowing about the offer? No. So an accepted cannot. So this comes from the previous rule only. If I have made an offer to you and you come to know about the offer and then you accept it, only then it is a valid acceptance. Not knowing about the offer is actually not an acceptance of the offer. So an offer cannot be accepted in ignorance of the offer. An offer can be conditional. That is, the offerer can put certain conditions subject to which the offer must be accepted. However, any condition which says that if you don't reply or if you keep quiet or if you don't reply, it is an acceptance. Such an offer is not valid. So it must not contain any term, the non-compliance of which would amount to acceptance. And a statement of price, a statement of intention, or an invitation to offer is not an offer. So, auction sale, issue of prospectus, the newspaper ads, self-service shops, discount sales, all of these are what? All of these are invitation to offer, right? They are not offer. What we actually think they are offer, they are actually not offer. Is it clear? Now, acceptance. What is acceptance? When the person to whom the offer is made gives his consent to the offer. He has said he has accepted the offer. When the offeree signifies his consent, thereto means to the offer, he has accepted the offer. Just like offer, even acceptance has certain rules. It must be unconditional. So if it is a conditional acceptance, it's a counter offer. It's not a valid offer. It results in the lapse of the offer. It's not a valid acceptance. It results in the lapse of the offer. So it must be unconditional. Acceptance, just like offer, even acceptance must be communicated to the person who has made the offer. Silence is not acceptance. So your silence cannot be treated as an acceptance of the offer. If you want to accept the offer, it has to be by words or actions. Silence is not acceptance. If no mode is given, acceptance can be in any reasonable mode. But if a mode for acceptance is given, acceptance must be in that mode only. If it is not in that mode, it's not a valid acceptance. If a time has been given for the acceptance, then it should be within that time. If no time is given, it should be within a reasonable time. And acceptance, silence is not acceptance, but the act of the parties or the conduct of the parties can be regarded as acceptance. So it may be by the conduct of the parties. And when it is made by the conduct of a party, it is an implied acceptance. That is by the acts of the parties. So before I move forward, I hope no doubt, nothing. You need to remember the rules. If you remember the rules, you can write it in your own words. Now moving on to communication and revocation. Just like offer and acceptance, communication of, I'm so sorry. Just like we just said that offer and acceptance must be communicated. So now let's talk about what or when does the communication take place. Now, if it is by telephone, no problem. You pick the call, you hear the call, and that's it. But Even when we say it is done over the call, it should be heard by the other person, otherwise it's not valid. However, if it is done through letters, not over the calls but through letters, then when does the communication take place? First of all, communication of offer is very simple. I post, done for me, you receive, done for you. So communication of offer for the offerer, I'm talking about offer since it's not written here. For the offerer, it is when he posts it. And for the offeree, it is when he when he receives it, right? If any specific day is given, that he opens it on a specific day, then in that case, whenever he receives, that will be considered to be the day of communication of offer. So very simple. If let us say A posts his offer on 10th, which reaches B on the 12th. Can I say communication of offer for A is 10th, communication of offer for B is 12th, right? If I say he read it on 14th, B read it on 14th, if a very specific day is given for reading, then that day will be considered as communication of offer. Now, communication of acceptance is just the opposite. In offer, I post, done for me, you receive, done for you. In acceptance is just the relation is just the opposite, ulta. For me, when you post it, for you when I receive it. So for the proposer, it is when the acceptor posts the letter, whereas for the acceptor, it is when the letter reaches the proposer. So it's just the opposite. So now let's say B posts his acceptance on the 15th, which reaches A on the 18th. So for A, it is 15th, for B, it is 18th. If you cannot remember anything, just remember the relation is inverse, ulta. So for me, when you post, for you when I receive. Acceptance is ulta. I hope it's clear. Which last page, Jayashree, are talking about? Now, rescission means to cancel, that is revocation. Just like offer and acceptance has to be communicated, even revocation must be communicated, because I'm not going to get a dream that you're going to revoke it. So just like offer and acceptance has to be communicated, even revocation has to be communicated. Communication of revocation takes place for the person who makes it simple. Here it is direct. If I am revoking against you, for me when I post it, for you when you receive it. If you are revoking against me, for you when you post it, for me when I receive it. So for the person who makes it when he posts it, for the person against whom it is made when he receives. So if I revoke against you, for me when I post, for you when you receive. If you revoke against me, for you when you post, for me when I receive. Now obviously there is a time of revocation. Offer can be revoked before the acceptance letter is posted. That is before 15, that is before the acceptance letter is posted, offer can be revoked. Acceptance can be revoked before the acceptance letter is received. So before 18th, before the acceptance letter is received, acceptance can be revoked. If it is received after that, acceptance cannot be revoked. I hope it's clear to all of you. Before I go to consideration, I'm giving you 5 minutes. If you have any doubts, you ask me, otherwise we'll move forward. Rules of acceptance, it should be unconditional. That is, you cannot put conditions subject to which the acceptance must be made. Just like offer, if acceptance must be communicated to the person who made the offer. Silence is not acceptance. So you keeping silent is not acceptance. But if your acceptance is given by the act, that is absolutely valid. So acceptance can be by conduct. If a mode is given for acceptance, if no mode is given, it can be in any reasonable mode, but if a mode is given for acceptance, it has to be in that mode only, otherwise it's not valid. It must be, if no time is given, it can be during a reasonable time, but if a time is given, it must be within the time specified. If you have any doubts in this unit, otherwise we'll move forward. Communication of acceptance is just the opposite. And when we say opposite, as in, just remember, for proposer when acceptor posts it, for acceptor when the letter reaches the proposer. Okay. Neeraj, is it clear? Neeraj, I hope it's clear. Now moving on to consideration. What is consideration? Technically known as quid pro quo. That means something in return. That is, when I give you something, I should get something in return. And what I get in return is my consideration. If there is no consideration, obviously the contract is what? The contract is void. What is consideration? If looking at the definition as given by the Act, when at the desire of the promiser, the promisee or any other person has done or abstained from doing, does or abstains from doing, or will do or abstain from doing, then each act or abstinence form consideration for each other. So the first rule says consideration must move at the desire of the promiser. However, the consideration may move from the promisee or any other person. Then consideration may be past, present or future. And each act or abstinence, basically my act is consideration for you. and your act is consideration for me, or your abstinence is consideration for me, my abstinence is consideration for you. So what are the rules of consideration? First of all, consideration must move at the desire of the promiser. That is, when I do something for you, I should get something in return, and what I get in return is my consideration. However, the consideration, instead of coming from the promisee can move from a third party. So instead of you paying the money, if your mom pays the money, it's absolutely valid. Your desire should be there. From consideration point of view, we both are the promiser and promisee. So from my point, I am the promiser, you are the promisee. From your point, you are the promiser, I am the promisee. And then consideration may be executed or executory. Executed is an act already done. Executory is an act yet to be done. That is just an exchange of promise. Consideration may be past, present or future. Present, which is going on. Future, which will be done. Past is previous request and subsequent promise. I first ask you to do the work, and after the work is done, I promise to pay. I first ask you to do the work, and after the work is done, I promise to pay. This is what consideration may be. Consideration is past, previous request, subsequent promise. In India, it is absolutely considered to be a valid promise. So even if you make the promise after the work is done, you have to pay for it. Then in every contract, there should be a give and take. However, consideration need not be adequate. Then consideration must be something which a promiser is not already bound to do. If I am already bound to do something and I claim extra for that, that extra is what? That extra is void. But if I do something which is outside my duty and I pay for that, it is what? It is valid. Then the last one must not be unlawful, illegal, or against public policy. Clear? Privity of contract. What is privity of contract? Only the parties to the contract can sue and be sued. Third party cannot sue. Right? Only the parties to the contract can sue and be sued. Third party cannot sue. So if there is a contract between X and Y, X can sue Y, Y can sue X. But Z has no right to sue. Even though Z can give consideration, but Z has no right to sue the contract. Who are you? Only the parties to the contract can sue and be sued. Third party cannot sue. लेकिन law में क्या होता है? लोचा. So there are cases where a third party can sue. The first one, if you are a beneficiary of a trust agreement, and as per that trust agreement, if you are supposed to receive benefits and you don't receive it, you can sue the other party. Right? You can sue even though you are not a party to the contract, you can sue the contract. In a family or a marriage settlement, if a person is named as a beneficiary of this family or marriage settlement, even though he is not a party to the contract, he can enforce the contract. Exactly, Shazan. When the rights of a contract are assigned to a third party, even though there is no contract with the third party, because the rights are assigned to him, he can enforce the contract. When a third party acknowledges his liability under a contract, even if he is not a party to the contract, he can still enforce the contract. And last, in case of covenant running with the land, when the purchaser of the land purchases the land which is subject to some covenants, then in that case, even if he was not a party to the original covenants, he is still bound by the conditions under which he makes the purchase. I hope it's clear, no doubts. The next thing is a contract without consideration is void, that we discussed at the beginning when I told you the definition of consideration, that without a consideration a contract is void. लेकिन law में क्या होता है? लोचा. So there are cases where without consideration also the contract is valid. What are the cases? The first one, natural love and affection. When out of love and affection, parties stand in a near relation, enter into a contract and get it written and registered, it's a valid contract. Then, in case of compensation for past voluntary service, when a person has voluntarily rendered services for the promiser, the services have already been rendered, the promiser was in existence and the promiser promises to compensate, it's a valid contract. Then, Time bar debt. In case of a time bar debt, if a person gives a written promise that he will pay a time bar debt, it's a valid contract. In case of an agency, obviously an agent will take consideration, but even if no consideration is paid to the agent, it is valid. Completed gifts. It's completed gifts, not just gift. Gift could just be a promise, but completed gifts means it's given. Once the gift is given, it's a valid contract, and then in that case, it is enforceable. You cannot take the gift back, it's valid. Charities and donation, a promise to give charity is not enforceable, but on the basis of the promise, if the other person has incurred any liability, he can recover to the extent of the liability incurred. And bailment, consideration may or may not be present. Even if consideration is not present, it's absolutely valid. So we are done with this unit. Before I go to the next unit, as again 2 minutes, you have any doubts, you ask me, otherwise we'll move forward. So, Damini, bailment is basically I give you the possession of the goods for a purpose, and once the purpose is attained, the goods have to be returned back. You lending your book from your friend, you giving the cloth to the tailor to stitch it into a uniform, valet parking, all this is bailment. So, when you lend a book from your friend, he doesn't charge you any money for it. But when you give the tailor to stitch a shirt, he is obviously going to charge you for that. So it may be with or without consideration. Can we move forward to the next topic? Yes. Minors agreement. Moving on to the next one, other essentials of minors agreement. First of all, an agreement with a minor is void. That means we cannot enforce the contract against the minor. However, minor can be a beneficiary. So if we have to receive minor has to receive something, he can enforce that. A minor can always plead minority. That is, if he fraudulently makes a contract and the contract is cancelled, he can prove the fact that he's a minor. And when he proves the fact he's a minor, the contract is discharged because a contract with a minor is void. However, when a minor, when the intention of the minor is to cheat, even if he proves his minority, he will have to compensate. So from this we get two rules. One, the rule of estoppel does not apply on a minor, and second, a minor is held liable for tort except for breach of contract. Then a minor is never personally liable for the necessaries supplied to him. The liability is against his property. If a contract is entered by the guardian of a minor, it is valid if it is beneficial for the minor. If it is not beneficial for the minor, it's not valid. A minor's act cannot be ratified. So on attaining majority, he can make new contracts, but he cannot ratify the old contracts. The old contracts are not valid. A minor can be an agent, but he cannot be a principal. Again, a minor cannot be a partner of a firm, but he can be a beneficiary. A company cannot allot shares to the minor. However, a minor can become a member of a company if it is by way of transfer, provided the shares are fully paid up. A minor cannot be declared as an insolvent. If someone gives a guarantee on behalf of a minor, the surety will be personally liable for the guarantee given. Then again, when we talk about a minor, he can be a joint promisor. However, except him, all the others will be liable. Correct? I think we have covered almost all of it. All the points we have covered. So a minor can be an agent, but he cannot be a principal. And if he is a principal, the agent will be personally liable. Now, when is the consent not free? That is, when are there flaws in consent? If it is by coercion. What is coercion? Threatening to commit a crime or the unlawful detaining of the property of another. When we say coercion, it is a physical force and can be by or on a third party. What is undue influence? When two parties are in a relationship and one party has a dominating position. So how can you have dominating when there is a real or apparent relation or fiduciary relation or unreasonable bargains or mental distress? All of this is dominating position. And one party uses that dominating position to force the other to contract on terms which are unreasonable. The force is a mental or a moral force, and since it's emotional, it cannot be by or on a third party, it can only be on the parties. And then fraud, 5 categories are considered as fraud. Assertion of the fact which one believes to be true but makes the other person believe it to be false. That is stating a fact which is true but you make the other person believe it to be false. Active concealment of fact, where a contract is made without an intention to perform, where a contract is declared fraudulent by law or any act fitted to deceive. Silence is not fraud, but in 2 cases silence is considered as fraud. First, where silence equals to speech, and second, when it is the duty of the person keeping silent to speak. Misrepresentation, where I make a statement which is not true, but I believe it is true. Right? It is not true, but I am under the impression that it is true. And because of this, I am causing you to make a mistake. It is an innocent mistake, but it is still causing you to make a mistake. Now, in fraud, intention is to deceive, whereas in misrepresentation, intention is not to deceive. In both the cases, contract is voidable, but in fraud, I will also get the damages. What are the consequences of fraud or misrepresentation or coercion or undue influence? It's voidable. But when one party uses fraud or misrepresentation, but the other is not misled by it, that is misguided by it, the contract is absolutely valid. Again, when one party uses fraud or misrepresentation, but the other party, if he would have used his diligence, would have come to know the facts, the contract is absolutely valid. Mistake of fact, if fact means what? The essential fact, that is the subject matter of the contract. If it is a mistake of fact, if it is a bilateral, bi means what? Both the parties. If it is a bilateral mistake, the contract is void. If it is a uni means what? One. If it is a unilateral mistake, the contract is valid. For everything we do, there is a law. So, and it is your duty to know the laws. If you are mistaken about the laws, you don't have any remedy. It is absolutely valid. Ignorantia juris non excusat. But if it is a mistake of the foreign law, it is what? It is treated as a mistake of fact. I can know the laws of my country, not the laws of other country. It's a mistake of fact and the contract is void. Now, before we move to the next topic, that is lawful object, if you have any doubts, you ask and then we move forward. Yes, Kunal, because we have covered the other chapters in the previous sessions. No doubts? Chalo, moving on to the next one. Unlawful object. So, what is unlawful object? The purpose for which the contract is made. This purpose should be lawful. If it is unlawful, it's void. When is it unlawful? If it defeats the law, whatever the law says, whether it is Hindu law, Muslim law, law includes rules also. If you go against the act, against the rule, against the Hindu or Muslim laws, it is void. If an agreement is fraudulent, that is also void. It's not fraud, it's fraudulent. Fraudulent is basically when the agent is acting outside his authority and the other party is aware of it. When it causes injury to a person or his property, it is what? It is void. Again, when it is immoral, we have some laws which are the laws of morality. And being a part of the society, we need to follow these laws. If we enter into any contract which is against these laws, it is what? It is void. Then against public policy, this is the main head, one of the biggest heads also. When we say against public policy, when it is public policies are made for the public, so it is the duty of the public to know these policies. If the public does not follow these policies, it's what? It is against law and hence void. What is against public policy? We have 10 different heads. The first one, trading with enemy. If my country is at war with another country, during war, that other inhabitant of that other country is my alien enemy. Any contract with them is void. Then, stifling prosecution. There are offences for which punishment by way of imprisonment is mandatory. If for such an offence we settle outside the court, it is against law and hence it is void. Champerty and maintenance. In both champerty and maintenance, one party is helping the other party to sue a third party. When you share the result of the litigation, it is champerty. When you do not share the result of the litigation, it's maintenance. It is void. But if it is in good faith, it is absolutely valid. Then the next one is interference with the course of justice. When you bribe the witness of any case, or you tamper with the evidences of any case, it is interference with the course of justice. Sale of public offices. When you bribe for a public post or a public title, you acquire a public post or a public title by by giving a bribe. It is against law and against public policy, and hence it is void. You want a favor from the other person, and for that you pay money. So interest against obligation, it's against public policy, and hence it is void. Then the next one is marriage brokerage contract. Finding husband or wife for another in exchange of consideration. It is against public policy, and hence it is void. Again, any agreement which stops a person from getting married. Any agreement which stops a person from going to the court to enforce the contract is void. But if we make an agreement that we will only go to one particular court and to no other court, that is absolutely valid. So a reference to go to the arbitrator is absolutely valid. And any agreement which stops a person from carrying a lawful trade. Just, I don't want you to carry, or maybe to create a monopoly, whatever the reason, it's void. However, if you stop a person from carrying a lawful trade and if it is reasonable, then it is considered to be absolutely valid. So, apart from restraint of marriage, restraint of legal proceeding, marriage brokerage contract, and restraint of trade, these are only void, the rest are also illegal. So we have completed almost 4 units, almost half of it. Now I'm giving you 5 minutes break. You can go and take a break, go and have water, attend nature's call, come back again. If you have doubts, you ask me the doubts, and then we continue. So I'll see you after 5 minutes. Okay, are you back? Are we all back? Yes, so we'll start. So the next one is succession. So moving on to the next unit. So this unit basically talks about performance of the contract and discharge of the contract. So succession. What is succession? Inheritance. What is assignment? Transfer of rights. Where succession takes place by operation of law, assignment takes place either by agreement or operation of law. So either by express agreement you can assign, or by operation of law the assignment takes place. In succession, you get both the assets and liabilities, but liability only to the value of the assets. Whereas in assignment, liabilities can be assigned only if all the parties agree to it. If one party is ready to perform but the other refuses to accept, so the party who is ready to perform has no obligation to perform again but has a right to claim the damages. And this party who refuses is called the breaching party. He is liable to give damages to the other party. Time and place of performance. If no time is given for the performance of the contract, it should be performed within a reasonable time. If day is given but no time is given, it should be performed during the business hours. If no place is given, it is the duty of the promisor to ask the promisee to fix a reasonable place. Just give me a second. No place is fixed. It is the duty of the promisor to ask the promisee to fix a reasonable day. And if I have to perform on a particular day, but I will perform only when you ask me to perform, it is your duty to ask me to perform the contract, right? Then time for performance. In some cases, time of performance may be of essence, whereas in some cases, time of performance may be not of essence. If the time of performance is of essence and you don't perform within the time, the contract is voidable. Now, when we say the contract is voidable, if you cancel the contract, you can claim the damages also. On the other hand, if you affirm the contract, you can claim damages only if mentioned. So, if a person rightfully cancels the contract, he can also claim the damages. On the other hand, if he affirms the contract, damages can be claimed only if it is mentioned beforehand, otherwise not. On the other hand, if the time is not of essence and you fail to perform within the time, the contract is what? Valid, but you can claim the damages. Oh my God, now what happened? Appropriation of payment. So basically when the debtor makes a part payment against which debt we adjust the payment is known as appropriation of payment. Since the debtor is making the payment, he can specify which debt he wants to set off. And if the creditor wants to accept the payment, he must set off that debt only. When the debtor makes the payment without specifying anything, since the creditor is receiving the payment, the creditor may at his discretion set off any debt, including a time barred debt, but he cannot set off a disputed debts and if a disputed debt. And if both the parties are not able to decide, then chronologically whichever debt is first in order of time will be set off first. And if there are more than one debt on the same day, it will be set off in their proportion. If the amount payment is similar to any specific debt, then it is an implied suggestion that it is only for that specific debt. Reciprocal promises, that is dependent promises. Reciprocal promises, as we say dependent, that is performance of one depends upon the performance of the other. That is, I will perform only when you perform. How do we fix the reciprocal promises? Reciprocal promises in a contract are fixed either by an agreement between the parties, that is, we mutually decide that I will perform first and then you, or vice versa, and we agree to it. Or it can be fixed by implication, that is, we don't fix the order, but the contract suggests who will perform first and who later. In case of reciprocal promises, if one party prevents the other party from performing, the party prevented has no obligation to perform but has a right to claim the damages. Restitution, when a contract is voidable and it is cancelled, or a valid contract later becomes void, whatever benefit we have received has to be returned back. To restore means to return back. So whatever, it's not damages, but rather whatever payment is made, whatever advance payment or anything is made which has not been which has not been and the contract has not been performed, then that extra advantage has to be returned back. Discharge of the contract can take place in 6 different ways: by performance, lapse of time, operation of law, impossibility of performance, mutual consent, and breach. By performance can be actual or attempted. Actual means we actually perform the contract, we are done with the contract. Attempted, one party tries, the other refuses. So one party performs but the other refuses. So by attempted performance, the contract is discharged. Lapse of time, the best example is time bar debt. Operation of law, in case of death, in case of insolvency, in case of merger of contracts, the contract is discharged. Then mutual consent, novation means substituting a old contract for a new one. That is, you cancel the old contract and you make a new contract. Rescission, cancellation of the contract. Here we don't make any new contract, but we cancel the old contract. Alteration, some terms of the contracts are changed. And remission, payment of a lesser amount in full settlement or payment of kind in place of cash. Then impossibility, existing at the time of contract, known to both. Both know it's impossible to perform. So for example, your girlfriend says, get me a star from the sky, otherwise shaadi ke pehle divorce. You ask Harry Potter to do it. It is what? Void. Unknown to both. Both parties are not aware that it is impossible to perform. Mutual mistake. But A wants to sell his horse to B, B agrees to purchase. Both A and B do not know that the horse is already dead. And known to one. It is void because one party is aware that it cannot be performed. So it's fraud. It is void because it's impossible to perform. But because it is fraud, the other party will get the damages. Supervening impossibility, when the contract was made, it was absolutely valid, but before the contract could be performed, changes take place, making the performance impossible, making the contract void. As such, we don't have any classification given in your book, but we have classified it so that it's easier for us to remember. So if the subject matter is destroyed after the contract is made, or after the contract is made, a war is declared, or after the contract is made, the promisor is, if the parties are dead and it's a personal skill contract, or after the contract is made, the state for which the contract was made no longer exists, or if there is a change in law after the contract is made, the contract is discharged by supervening impossibility. Breach means non-fulfillment of the terms of the contract. It can be anticipatory or actual. Anticipatory means prior to the due date. Now, when prior to the due date, I come to know the other party will not perform, I can either cancel the contract on that very day or wait till the due date. If I cancel the contract on that very day, I will get the damages. If I wait till the due date, now on the due date, if the other party performs, I have to accept it. But if the other party does not perform its actual breach, I can cancel the contract and claim the damages. So before we go to remedies for breach, any doubt you have in this unit, you can ask before we move to the next topic. So no doubts? Okay, so moving on to the next one. What are the remedies for breach? First of all, damages. Supervening impossibility. When the contract was made, it was absolutely valid, but before the contract could be performed, changes take place which makes the performance impossible, making the contract void. So let us say you hire a painter to paint a picture for you, but before he could complete the picture, he is dead. Now, obviously, it's a personal skill, so you cannot ask his legal heirs to perform. So what happens to the contract? The contract becomes void. This is supervening impossibility. So damages, rules of damages are: ordinary damage can be claimed as a right. Special damage can be claimed only when there is a notice of the special loss. Remote damages can never be claimed, and any damage under a quasi contract can be claimed. So what is ordinary damage? Can be claimed as a matter of right. The fact that there is a breach gives me a right to claim the damage. It would be market price less contract price or contract price less market price, depending on whether the price goes up or down. Special damages cannot be claimed as a right, only claimed when there is a notice of the special loss. So it's not my right to claim these damages. I can only claim them when I have given a notice of the special loss. Nominal damage, there is no damage at all, but still, just to respect the Indian Contract Act, we give a damage which is as less as 10 paise, 1 rupee. This is nominal damage. Vindictive or exemplary damages, they are basically punitive, that is punishable in nature, and since they are punishable in nature, they are only awarded under two situations. What? First, breach of contract of marriage, and second, wrongful dishonor of a customer's check. Then penalty or liquidated damage. Penalty, they both are damages already mentioned in the contract. Penalty is something which is very high, not actually suffered, whereas liquidated damage is something very near to the actual damage suffered. You will only get what you have suffered or what is mentioned, whichever is less. Then rescission, when one party is ready to perform but the other refuses to accept, the aggrieved party can sue the other party to cancel the contract and claim the damages. Quantum mediate, as much as is earned or as much as is merited. If I have performed a part of the contract, then whatever part I have performed, I should get payment for that. If the contract is not separable, I will not get any payment, but if the other party accepts it, he has to pay for the part that he has accepted. Specific performance, sometimes in a contract, the goods may not have substitutes. So their damages are not adequate. I would rather like to get the goods itself, or damages are not an adequate relief. That is, damages cannot be substituted for non-performance. There I will sue the party to perform the contract and not for damages. Injunction, whenever there is a negative term that I will not do this and the party breaches that negative term, then the aggrieved party can sue him to stop him from doing that negative act. Remote damage, there was this one real case. A person, he was traveling to some place and there was no direct train, so he had to switch over trains, and because he missed the first train was late, he missed the second train, for which he had to walk a long distance, for which he had blisters on his feet. So he claimed damages for those blisters on his feet. He could claim damages for delay, but he cannot claim the damages for the blisters on his feet. That is considered to be a remote damage. Damini, I hope this helps. If not, I'll give another example. Contingent contract. There is actually no contract, but a contract. I'm so sorry. Contingent contract is basically a contract which is dependent on an event which may or may not happen. So A says to B, I will sell you my land if I inherit it from my father. So the contract is that A will sell his land to B, but it depends on what? That whether he inherits it from his father or not. If he inherits, he will sell, otherwise not. Right? If he inherits, he will sell, otherwise he will not. So you will get the job provided you become a CA. So if prior to your result, they take an interview. So if you clear your CA, you will get this job. So this is what? Contingent contract. It can depend on the happening or non-happening of an event. If it is dependent on the happening of an event, it is valid when the event happens and it is void when the event does not happen. If it is dependent on the non-happening, it is valid when the event does not happen and it is void when the event happens or does not become impossible. It can depend on a third party. If it is dependent on a third party and if the third party acts accordingly, the contract is valid. But if the third party does not act accordingly, the contract is what? Void. If it is dependent on impossible event, A says to B, I will give you 1 crore if I get a star from the sky. Now this is something which is impossible to perform. It is what? It is not valid. It is void ab initio. These are valid. And if that event does not happen or happen, then it becomes void. But such a contract itself is not valid. Quasi contract, there is no contract between the parties, but a quasi means not real but looks like. There is no contract between the parties, but a contract is created by law. That is, law creates a contract. So if, let us say, I had to deliver goods to you, but by mistake the goods are delivered to someone else, there is no contract between me and that party, but that party will return the goods back to me or pay me the price. This is on the basis of a quasi contract. When I supply necessaries to you, you are a minor, or I supply necessaries to a lunatic's family. As between me and the minor or as between me and the lunatic, there is no contract, but there is a quasi contract according to which I will get my money back. This is what? Quasi contract. If you are supposed to make some payment and I make the payment on your behalf to protect my interest, I will get the money paid. So for example, you sold me a land on which the government taxes are due, and if you don't pay the taxes and you sell the land to me, if the government seizes the land, it will be my land which will go, so I pay off the government, so I can recover that taxes from you. If a person has done any work for you, not intending to do it gratuitously, that is, he has done the work to get paid for it and you enjoy the benefit, you have to pay for the work he has done. If a person finds goods belonging to another, there is no contract between them, but there is a quasi contract that the finder will search the owner and return the goods back to him. It is the duty of the finder to take care of the goods, to not mix the goods with his own goods, to trace the owner and to return the goods back to him. But it is also his right to claim any money that he has spent, to claim reward if there is a reward declared, to sell the goods if the goods are perishable or the owner is not found, or the owner is found but he is not giving the lawful charges, which are 2/3 or more of the value of the goods. And he has a right of ownership against the whole world except the owner. That means when the owner claims the goods, he is liable to give, but otherwise he is not liable to give the goods to anyone else. Ashok, I'm sorry, but there is no Indian Contract Act 2013. It's Companies Act 2013. It is Indian Contract Act 1872 only. Okay. So with this, we have completed this topic. Indian Contract Act we have completed. That was a quick revision. Obviously, it was quick. I don't want to waste too much of your time also, because you have exams tomorrow. You would want to sit and study on your own also. But I hope this has really helped you, because at least it's a refreshing of the whole thing. So now if you sit and study for the next 3-4 hours, you'll be able to finish off Indian Contract Act. So next 5 minutes, if you have any doubts or anything, clarification, we will do that. Otherwise, we'll end this session here. And it is not 2013, okay? No problem, no problem. No, that is okay. That's great, Dashwant. All the best. Thank you so much, Ashok. Thank you so much. All the best to all of you. If you have any doubts, please ask me. Thank you, Neeraj. My blessings are always with you. Nothing makes me more happy than seeing my students, rock and roll in the exam. Yes, Kriteshni, you can surely ask. That's not an issue at all. And I want a message from all of you tomorrow that, ma'am, the exam was rocking, okay? Don't waste your time, study, but do have a good night's sleep. Otherwise, exam will be a problem. Sleep well before you go for the exams tomorrow. It should be an amazing sleep. You should have an amazing sleep. Thank you. Well, Kriteshni, generally in that case they tell you write about this condition or write about the rights of caveat emptor. If they say write about the rights or liabilities in case of caveat emptor, then you will mention caveat emptor. Otherwise, you will write as per the conditions. Yes. I'll be waiting. All the best to all of you. Go and rock your paper. So in that case, I'll end the session here. Is it okay? I'll end the session here, everyone. Chalo, all the best. You people, your paper should be as rocking as you are. Just as lit as you are. You know everything. So if you get confused also, do nothing. Take a deep breath. Read the question again. You will get the answer. Because you have worked so hard. So you know all the answers. So don't panic. Don't do anything. If by chance you see a question, you don't know the answer, just skip it for the timing and go to it at the end. Please time your paper. Don't forget to write English. Don't forget to write law. And all the best. And I want to see a message from all of you tomorrow that, ma'am, the paper was amazing and rocking. Take care. Bye. All the best. And keep rocking your papers for the rest of the paper.